Okay, well, good afternoon, everyone, and good morning for those of you on the West Coast. My name is Paul Singer. I'm a partner at Kelley, Drye, and am the co-chair of our state attorneys general practice. Pleased to be joined today by Beth Chun, who is a senior associate and works with me on state AG matters. And welcome to State Attorneys General 102. For those of you that attended our last webinar, which was, you guessed it, State AG's 101, we covered a variety of topics about Attorney General Consumer Protection Authority and gave a few practice tips on how to stay off their radar and how to respond to an investigation if you become the subject of one. Today, we're going to pick up where we left off last month. And we're going to give a little bit more context into some of those areas. And we're going to answer some questions that came up from folks at the end of last month's webinar. So today we're going to keep things pretty short. We're going to clock this in right around 30 minutes. And we're going to cover three main topics. First, I'm going to talk a little bit more about some additional background on the scope of Attorney General investigative authority. So basically what kind of things they can ask for and more things to think about in how you respond to an AG investigative request. From there, Beth is going to talk a little bit more about the consumer complaint process that states have and how they differ among the various state AG offices. And then finally, I'm going to talk about notice, both pre-suit and pre-investigation notice that may or may not be required in certain states, and really especially what you can do to try to stay on top of where AG investigative trends may be leaning. So with that, we will jump right into things. One more quick housekeeping note. For those of you seeking CLE for this, you should have received a form that was attached to the calendar appointment. At the end of this webinar, I'm going to provide a code that you will put on that form and you can submit for CLE credit. So let's turn to what states can get with their various investigative authority. Last time we spent a lot of time talking about civil investigative demands or CIDs specifically, but we did mention that AG investigatory authority can go well beyond just the types of documents that are requested from a CID. Different states may be able to obtain evidence and information through a variety of different tools. So just by way of example, we've put up two statutes here just to compare between Massachusetts and Texas, both of whom have specific authority granted in their codes for consumer protection matters. And here, for example, Massachusetts has a list of additional information they can obtain, such as taking oral testimony from a witness and then also submitting written interrogatories. Whereas Texas, you'll see, has a list of available investigative tools that includes an examination under oath, sampling merchandise, but notably does not have the specific ability to ask about interrogatories or to send interrogatories. So this is just one of many examples that can be made when you're comparing state authority. And really the takeaway and why this matters, right, is when a state comes and you learn of a state investigation, one of the first things you should be aware of is exactly what tools are in their toolbox. And so understanding and knowing the different types of information that states can request is really important at the front end, because that's going to help shape how the direction that investigation may go. So beyond just the types of information that a state can request, it's also important to make sure you understand exactly what authority the AG is using when they've started an investigation. So again, just for comparison's sake, we showed you the language on the last slide from the Texas Consumer Protection Statute and the types of information that can be obtained. By way of comparison, though, Texas antitrust law has a different civil investigative demand authority and has some pretty significant differences in the scope of information that can be collected. So, for example, the antitrust statute provides specifically that the state can submit interrogatories and obtain information that way. Unlike the Texas consumer statute, oral testimony that's obtained through the antitrust statute is kept confidential. The Texas consumer statute only makes documents obtained through a CID confidential. The transcripts of oral testimony may be subject to open records. And so, again, that's a pretty significant difference to think about when you're providing that kind of information to the state. Another important difference is that under the consumer law in Texas, documents, once they're provided to the state, just fall under the general document retention policy of the state. And so, the state is going to be required to maintain those documents for several years before they can ultimately get destroyed. Under the antitrust statute, you're entitled to ask for those documents back. You can ask that they be returned at the end of an investigation, and then you don't have to be concerned that, perhaps sensitive information that you have provided is now, out in a variety of places. And then finally, under the antitrust law, there's a specific provision that states that information that's requested is essentially limited by the rules of procedure. So it's the same type of information that you could request through a formal discovery request if you were in litigation. The consumer protection statute has no such limitation. And so seemingly the AG is able to obtain a much broader set of information than, perhaps they could under the standard rules of discovery. So why all this matters, right, is that, again, these are important distinctions to think about as an investigation is beginning, and especially now that we are in a world where AGs are starting to blend their different plaintiff side authority in cases, notably in the consumer protection and antitrust realm, where they have brought a number of cases in recent years that assert both consumer protection and antitrust violations. Understanding these differences between their investigative authority under those two laws is really critical, because it may provide you with a window to actually engage and talk with the state about which authority perhaps different requests are being made under, and maybe even use that to help protect information in a different kind of way than perhaps it would have been if the AG had just issued it under one statute versus the other. So again, this is just sort of a something to keep in mind as potentially you become subject of an investigation. And so then, to make things even more complicated, there are some states that just don't have any specific authority based on unique consumer law or antitrust law, but generally they just have the authority to investigate corporations. In fact, the ability to examine books and records of corporations is one of the oldest powers that states have, and many states still have that general authority that exists. And so, when you again look at a statute like in California, where this is not something from their consumer statute, but rather is just a broad authority to issue subpoenas, compel testimony, promulgate interrogatories, it's a much broader authority than the narrower constrained authority that they may have under a specific statute. And again, why that matters, right, is because if you are looking at the scope of an investigation and you want to be able to perhaps make an argument that this is really outside the realm of consumer protection authority, it may not matter when you have a state that has this kind of broad authority to be able to look at the books and records of a company. Arizona is just another quick example that shows you that they have both a specific provisions that apply to consumer protection law, but then also have broad authority under a separate section to issue subpoenas and conduct hearings that's separate and apart from any tied authority. So again, just knowing the full scope of what states can ask for is critical to those early stages of an investigation. So now let's talk a little bit about, you've received the request. What do you do if you just don't want to respond, right? I mean, there are many times that companies may think about challenging a CID. Last time we talked about some of the pitfalls that can occur when you try to challenge the scope of the AG authority, because pretty universally, courts continue to hold that attorneys general have very broad authority to be able to conduct investigations and ask for information. And the bar that they have to meet to be able to send those kinds of requests is relatively low. So we wanted to provide a few more examples for everybody just to show some of the more unique arguments that have been made. But you'll notice that same consistent theme that these arguments ultimately fail because, again, AGs are going to be able to obtain all sorts of investigative power. The first case that we're going to talk about is this ABC company versus Kentucky. ABC was not the name of the actual company. You'll see the related matter below, American National University, which actually was the name of the company that was the recipient of a CID. American National decided that they wanted to challenge the scope of the CID, but they didn't want to have the negative publicity that would come with making a public filing. And therefore, they would have to acknowledge that they were now the subject of what was to that point a confidential attorney general investigation. And so rather creatively, they decided to do it through an anonymous filing, and they filed it as ABC Company versus Kentucky. At the lower court level, this was thrown out pretty quickly because there was no authority to challenge a CID anonymously. Ultimately, while that issue was one that was brought up on appeal, in the meantime, the name of the entity became known and became public, and there was some press around it. And so that issue ultimately got dropped because, again, at that point, it was moot. But, really, I think the underlying point is that, this is something that you have to weigh as a business when you're thinking about challenging a CID, is that if you're going to go into court and actually make that claim, you may now be revealing an investigation that otherwise you may not have had to reveal, because ultimately if the AG decides not to pursue something, they could shut it down without anything becoming public. A little side note on this, the end result of that, you'll see this related matter that was 5 years later. That case ultimately went to trial, and American National lost. And when they appealed the case, the decision was largely upheld, but it was reversed on one piece that I will just note, because it could be subject of a whole nother webinar, which is how to properly count violations, and then associated with that, how you determine civil penalties in a matter. This was a case where ultimately the trial court found that a per day assessment of penalties was warranted, but at the appellate level, it was found that that conflicted with the statutory language that talks about a per violation amount. And so again, what's a violation is something that is largely undefined throughout the states. And so there is a lot of different interpretation that can happen, and that really weighs on what kind of penalties you may be facing. The second case is the Schneiderman case. This was a charities case where the former director of a charity, who had not been director for many years, was forced to testify about the record keeping and time that he was the director. He tried to challenge the request, saying that he was not an individual that the AG basically had authority over and that could be listed as someone who could provide testimony. The court dismissed that pretty easily because the statutory language of who the AG can request testimony from is incredibly broad and includes just sort of a catch-all of any other witness that has information. And so, it didn't matter here that this was a former director or that he didn't have some of the specific records that they were asking about. Ultimately, the court said if the AG wants to take his testimony, they can, because the AG has that broad authority. The final case, the Brnovich case, this was a tenant matter. Again, there were a number of challenges to the CID itself about the scope and the breadth of it, all of which were pretty quickly denied for all the reasons we've talked about today and last month, that, again, the AG can issue very broad requests. But a really interesting argument here was that the respondent tried to claim that because there was a 1.5 year gap between the one consumer complaint that the AG's office received about their conduct, and then the issuance of the CID, they tried to claim that this was some retaliatory action, and that it really demonstrated that this wasn't something that was in the public interest. And here the court made very clear that a state's dilatory conduct doesn't affect the validity of the CID. And so it didn't matter how long it took for them to actually issue the CID. It's still well within their authority to issue it. Two other really quick notes on this one too. There was attorney's fees awarded to the state because due to this challenge that ultimately were upheld on appeal. And also notably, the Court of Appeals here made the explicit statement that the AG is not bound by the rules of discovery in making these requests. So again, recognition of the broad AG authority, and it can cost you money if you have to challenge these CIDs because, again, challenging this broad authority is usually going to result in that kind of dismissal, and it may force you to have to pay the fees of the state. So with that, I will pass it over to Beth to talk a little bit about the consumer complaint process.
Thanks, Paul. So states, just like states have different CID authority and different scope available to them, states also have different policies and sometimes statutes governing how they handle the receipt of those consumer complaints. And so there are many states who will actually engage in a complaint mediation process, which a lot of you may be familiar with, but how that works actually depends on each state. And so in some states, they go through a much more formal process, like with Vermont and Maryland listed here. If you look at their websites, you can see that this mediation process is likely much more engaging than some other states. So Vermont says, we can try to help you resolve a consumer complaint with a business. This is not a formal legal process. We cannot guarantee a response or resolution. However, we find we are often able to help consumers like you get responses to complaints through that process. That's a little bit different than what some states have on their website, where they specifically are notifying consumers that they may not be able to help them. On the Maryland's website, they go ahead and say the Consumer Protection Division mediates most complaints, and it talks about assigning the complaints to mediators, and the fact that they have volunteer mediators and mediation efforts is all described in there. So it's a much more formal process in Maryland than it is in some of the other states. Both of those states have larger offices dedicated to a more formal mediation process. So that could even include like phone calls with those offices from their trained analysts. And so they're a lot more likely in those more formal states to actually follow up with each complaint that they receive because they have a more formalized process like this. But as you can see, there are also a lot of states that have a much more informal process. It may be referred to more as a dispute resolution rather than mediation, because there's not necessarily going to be a lot of back and forth going on. A lot of times this could consist of form letters being sent back and forth with a business to attempt to get a response in that way. But there are even also several states that don't even engage regularly in resolving complaints in that more informal manner, but rather use their complaints more for informal processes like reviewing trends. So as you can see from these websites for Hawaii and Georgia, they explain more explicitly to their consumers that they're more just using their complaints in their database for their internal purposes, and they have limited resources to actually go out and resolve those complaints. So because of what we just talked about with whether states are mediating to different degrees, it's unlikely that a business is going to actually have seen all complaints that state AG's offices will have received about their business. So, how can you go about trying to actually see all the complaints that you have? There's a few different ways that you can try to do that. And one of the ways is that there are certain states that actually have databases online that contain certain complaint information. They may contain searchable databases with some valuable information in there, but then again, they also don't usually contain the entire complaint from the consumer. Massachusetts and Virginia are some examples of states that have actual searchable complaint databases online. You can also attempt to use a state's different FOIA or open records laws to request copies of complaints about your business. But this should be something that you should consider the impact of, because this will necessarily cause the state to potentially review all of your complaints in order to provide the production. So you should consider whether that's something you want to proactively encourage that state to do. And it could also be costly because states calculate their open records responses different ways. Sometimes it's by page, sometimes it's by the hourly time spent by the different people responding. So those are all things to consider. But then also there's the fact that you may actually submit a FOIA request and not actually get anything in response as well. So you may have put the state on notice that you're interested in their complaints. They may go off and take a look at those, but you may not even get anything in response because certain states have their complaints considered part of their investigative records, and they are exempt from responses under their open records statutes. And finally, you could also try to kind of go around the state AGs and go straight to Consumer Sentinel, the FTC's complaint database, and make a FOIA request to the FTC, which could work in some ways because several state AGs and BBB offices do contribute to Consumer Sentinel. And states do often use Consumer Sentinel as a resource like we talked about in our 101 webinar. But while you could get some valuable information from a request like that, there are still many state AGs offices that don't contribute their complaints to Consumer Sentinel. So again, you could be left with the same problem where you're not able to view some of the state's complaints. And now I'll turn to Paul to talk about pre-suit notice.
Yeah, and thanks, Beth. And before I do, I'll just note that if you're wondering why Beth knows so much about consumer complaints, she actually, when she and I were at the Texas AG's office, she ran the consumer complaint process for a number of years, and so got very familiar with some of the nuances that we had in Texas, and then some of these differences nationwide. And it really does sort of, I think, reflect perhaps the biggest takeaway from this webinar today that I hope you leave with, which is that you really should stay on top of your complaints as a business, right? And understand and know that you are not receiving all of them. So, making sure you figure out a good process either internally or through the use of counsel to get those complaints from states that have them available but don't send them to you, so that you can make sure that you are addressing them and know what trends are happening is absolutely critical. And you need to be incredibly thoughtful in your response to consumer complaints, because what you put in writing and what you respond to a complaint could come back to haunt you in a later investigation or even litigation, because it's essentially an admission by you about some particular incident. And so that is just absolutely critical in my mind about staying off the AG radar and ways to minimize the kind of impact that complaints could have. So let's turn quickly to notice, and it's kind of a quick topic, because when it comes to what rights you as a company have to being able to receive notice about an investigation or pre-lawsuit, in most states, the answer is none. You have no right to that, and there's no requirement that notice be provided. And even those states that do have some level of notice, it may be a fairly limited notice provision. So we've put up language from the Texas statute here that just makes clear that you as a business only have the right to know in general of the alleged unlawful conduct prior to a lawsuit being filed. Well, if you're subject to an investigation, odds are you've received some sort of inquiry from the state, either a CID or all the types of information that we talked about earlier. So you are on notice of the types of unlawful conduct that are being alleged. And so there may not be a specific notice requirement. And even if you successfully challenge the state for a failure to provide that notice, it's entirely possible that the only remedy you're going to get is an abatement of that case for the statutory notice provision, which like in Texas is 7 days. So you're not really getting much out of that at the end of the day anyway. Now, by contrast, however, in an individual consumer action, or for those states that allow for class actions under their consumer protection laws, those generally there is a notice requirement. So generally you are now going to be subject to some level of notice, and there may even be a right to cure that exists. So, from like a public policy standpoint, this makes sense that legislatures are creating a structure like this, right? AGs have significantly broader authority to do pre-suit investigations. They generally tend to keep those investigations confidential until they make a determination and then have some sort of public filing. And so, there are going to be more, there's going to be more leeway provided to the state in terms of things like pre-suit notice, et cetera. Whereas in an individual cause of action, there's going to be additional steps that have to go through, including, perhaps giving the company an opportunity to remedy the situation to avoid, again, unnecessary litigation or clogging the courts. And so it kind of makes sense why structures like this exist throughout the states. But it also serves as just, a general reminder to everybody that AG authority is significantly different than individual authority. And so don't think, just because perhaps you've had experience with an individual or class action under consumer protection laws, then what your rights are when it comes to an AG investigation, because they may be very, very different. And there are significantly different remedies that are available at the end of the day. And then one other note that we'll make in terms of notice, just like there may be requirements that you as a company receive notice prior to an action, before bringing a private action or class action, there may also be an obligation that the individuals notify the Attorney General. And so here we've provided a copy of Texas's law that requires pre-class action notice, that has to go to the AG, and it gives the AG the right to actually intervene in a case. Same thing in Louisiana. Louisiana requires that, if there's a judgment, that there has to be a copy that's sent to the AG. And so again, sort of keeping the AG in the loop on these kinds of things is consistent with that broader public policy that we talked about. These notices also, may be something that's an open record and something that you can perhaps obtain to keep track of what kind of trends are happening in the litigation space that you may want to pay attention to, especially if they're pre-suit, so that you know what kind of trends are happening. With our last minute, Beth, you want to quickly mention CAFA and some of the obligations there?
Sure. So under CAFA, typically there's a section 1715 requires notification to the appropriate federal and state officials. And usually state AGs are the appropriate state officials that will receive CAFA notice. So states will often receive, they should be receiving every notice of every class action containing class members in their state. So they may be receiving hundreds of notices per year. And so they can kind of pool resources and share information with each other. States often participate in working group calls, like we talked about in the 101 webinar, to discuss the notices that they've received under CAFA. And when I worked at the AG's office, one of my duties was serving as a co-chair of the CAFA working group. So some of the things that states might discuss are some of the reasons that states are monitoring the notices are actually to monitor fairness, as the statute is sort of providing for, but they're also looking at preserving their own enforcement rights. And sometimes this, along with those other types of notices that Paul's listed there on the slide, could be other avenues that states are actually coming up with their own investigations, because if they find that the private class action has not resolved the concerns that they have with something, then they may seek to obtain additional injunctive relief or other types of relief following a class action.
So that brings us to the end of today's short webinar. Like promised, we got it in right at 30 minutes. So, we just wanted to thank you for your attendance. Obviously, if you have any follow-up questions or need any additional information about any of these topics, please feel free. Just hope that you will join us in our next upcoming webinar from the Ad Law Practice Group, where we're going to be talking about protecting employee HR data and complying with data privacy laws. We've got information here on the screen. You can scan the QR code, but you can always visit us at our website through Kelley Drye and and the Ad Law Access page. And you can always follow us through our link tree to see all of our various updates on consumer protection issues, advertising law generally. We try to maintain a robust resource for everyone on all topics that can impact you. So, please make use of that. And with that, I will thank you all for your attendance today. And we look forward to future engagements and talking with folks about these issues in the future. Thanks so much.
Thank you.